I would see an employee handbook that says, it's against our policy to be engaged in a relationship or to flirt or whatever with a coworker. But I just don't think that's practical anymore.
That's Leah Stiegler, principal at the Virginia-based law firm Woods Rogers. She is a management side, labor, and employment attorney who works with business leaders and HR teams nationwide. She advises employers through the entire employment life cycle, from recruitment to termination and severance, to ensure their compliance and keep them out of court. You can catch Leah on her YouTube series called What's the T in L&E, where she and a colleague cover the latest questions that keep HR professionals up at night. I'm Germain, and I'm the host and producer of Dear Human Resources. In this episode, Leah is going to discuss the legal side of workplace romance and various legal advice. Welcome, Leah.
Thank you. I'm excited to be here.
So let's start with workplace romance. How popular is workplace romance?
It's actually very popular. I think probably more. Well, let me ask you this, Marie-Lynn. What do you think is the percent of people that reported having experienced a workplace romance in the United States?
I don't know that, but I tell you what I know. Most people today meet their spouses through work.
Yeah. And that's because we spend in the course of our lifetime more than probably 90,000 hours at work. And it is not unlawful to fall in love at work. I always like to make that clear. As a lawyer, I love to talk about the legality of workplace romances, but it is not unlawful to fall in love at work or outside of work. But yeah, there was an interesting article from SHRM in 2023, the Society of Human Resources Management, that said 27% of people reported having experienced a workplace romance. And then in February of 2023, the Washington Post did an article, and they reported that it was sort of generational based, but about 33% of Gen Z employees and millennial employees, like myself, reported having experienced a workplace romance, compared to 23% of the baby boomer population. But I also think that maybe the baby boomers weren't as honest. I think that theirs was just equally, they equally experienced probably the same amount of sort of workplace flirtation and whatnot.
It doesn't surprise me. You know, most of our acquaintances today are through work. I mean, we don't necessarily know our neighbors anymore. We don't connect to our neighbors the way we connected to them, let's say 30 years ago. And we do have friends, but the majority of our friends are through social media. So it doesn't surprise me at all that today we would meet most of our future spouses or partners through our workplace. How does workplace romance impact the dynamics of a team?
Oh, well, that's interesting. So, I mean, I think you could probably see, I mean, in one sense, there are interesting pros that come along with workplace romances. Employees who may have a crush on other employees in the workplace may be more excited to come to work. They may show up on time. May be more excited to work longer hours or work on projects. Whether they're distracted or not, they're at least there and motivated because they like their coworkers, or in a sense. I think the real concern for employers is that you have all sorts of issues, from gossip and rumors that are going around to favoritism. You may have an altercation. I can give you some examples on that. And then also legal issues, right? I mean, love is beautiful, right? But we have to address the reality too, which is that while we may fall in love at work, people also break up. Not necessarily just a divorce, but going to as far as a divorce, right? But a breakup as well. And so, you as an employer, and employers have to deal with the aftermath of that.
Some employers refuse that employees date within a particular department. Is that legal?
Yeah, absolutely. I think it's not going to work for an employer in today's world to take an approach of zero tolerance, to say, I mean, I used to see that when I first started 10 years ago. I would see an employee handbook that says, it's against our policy to be engaged in a relationship or to flirt or whatever with a coworker. But I just don't think that's practical anymore. I mean, I think if you look, you would lose theoretically 33% of your employees based on those polls that we just talked about. So I don't think you can take a zero tolerance approach. But I do think you have to have some boundaries and rules, right? Like no PDA, no fraternization policies. You definitely have to address the subordinate to boss relationship, right? And the big issue there are the legal concerns surrounding quid pro quo harassment, right? This for that harassment. So if someone is in a power dynamic where, they're in a relationship with a superior and for whatever reason that subordinate is terminated or something negative happens to them in the workplace, then they can turn around and sue. And I've seen a few cases where they turn around, they say, hey, I experienced sexual harassment in the workplace. My boss pressured me into a relationship. The boss is saying, well, no, this was totally consensual. Well, that subordinate's going to be able to say, well, I had no choice, right? There's a power dynamic there. If I were to refuse your advances, I wouldn't have kept my job. So you have that concern. And so I think, when employers are considering what boundaries to put in place, I like the boundary of you shouldn't be in the same department. That's a good boundary. If that works for your workplace, or you can put them on different shifts or in different parts of the workplace, then yeah, I think that makes sense because you don't want that distraction in the workplace.
As you just said, it can be a distraction, not just when they fall in love, but when they fall out of love.
Oh, I had
Um,
this
yeah,
interesting case a few
go
years
ahead.
ago where they were actually both in management, but one was sort of the top of the facility, and the other one was maybe still in the C-suite, but not the head of the facility, right? And the male was the head, and the female and the male people noticed them flirting a lot, right? And their offices were next door to each other, and they'd always go back and forth to each other's offices. They both worked long hours and would spend a lot of time together, always be walking to their cars together. And, they could kind of play it off as, they're friendly or whatnot. Well, she ended up getting terminated, not by him, but by her direct boss. And she turned around and she sued for sexual harassment. And and when she filed her lawsuit, she had all sorts of evidence that you would look at as a reasonable observer and say, yeah, that seems like sexual harassment, right? There were flirtatious messages from him, sexts, so to speak. There were pictures of his genitals that he had sent her. Oh yes, this does happen in the workplace, right? She claimed that he would come to her house frequently and whatnot. Well, and so that put us, when we reached out to him and we started interviewing him, he's like, no, it was totally consensual, and he did produce text messages from her as well as pictures from her or whatnot. But it was hard because it's going to be her testimony against his, right? It was her. She ended up saying, I felt like I had no choice. I mean, my job was on the line. If I refused his advances, then, what was I supposed to do? It was really interesting. She had sent him some of I'll call them sexy photos that she had sent him. They were from years earlier that you could tell. I mean, she had lost a little bit of weight since then and, had looked a little bit different, had blonde hair versus brown hair and whatnot. And she had edited them with like filters and stuff. And so when we first actually tried to argue, well, she clearly liked him. She's sending him, the hottest pictures of herself from a few years ago when she was like looking her best in her 20s and this all, whatnot. And she was editing them to take out away her blemishes. Like, you don't put in that much work for your harasser, right? That was one of our arguments to try to prove that for her it was consensual. Well, turned it around and smartly, her attorney spun it on us and said, well, no, she didn't. When he was begging her for photos, she didn't want to take photos for him. So she just went into her archive of sexy photos, which I'm assuming, now I'm learning maybe many people have these, and sent him old photos, right? And so she was able to kind of make the argument. We ended up settling the case, but she was able to make the argument, that she felt forced into doing it. This is one reason I often will recommend to clients to use a love contract. Have you ever heard that term?
No, I have not, but please tell us about it.
Yeah, it's not a marital contract. That's actually a legal contract filed with the court or anything like that. But it's kind of a fun term for basically a disclaimer that HR professionals can, when you're aware of two employees that are in a relationship, whether it's two coworkers or a subordinate to a supervisor, you have both employees sign a document that basically disclaims that they are in a workplace romance or in a relationship or however you want to define it. We always use interesting language as broad and vague as possible because you'll run into the Gen Z generation or the millennial generation who refuse to define certain things as relationships. They'll call them situationships or no, we're just friends with benefits. And so we refuse to sign it. But regardless, we make them sign it. And it's basically a disclaimer that all the conduct they're experiencing is consensual. You have in there a reiteration of your sexual harassment policy and also the reporting avenues, and you have them sign an acknowledgement that they know that if they're experiencing harassment, they know that they can report it to HR, to any other member of management. And that protects the company so that if in this case where I just gave you the example of that lawsuit that we had, if we had had something like that, that she had signed that, I think it would be really hard for her to sit there on the witness stand in front of a jury and say, I had no choice. I had nowhere to go. He was the head of the facility, right? Because you have a document sitting there right in front of her with her name on it and signature on it saying that she knows she can report to other people and all conduct she's experiencing up to date is consensual.
Right. So that's a legal step that an employer can take, right? If they have employees engaged in consensual relationships.
Yeah, and I think you also you want to make your boundaries clear, what your rules are, right? So in that, like I mentioned in the employee handbook, I used to see policies that said absolutely no workplace romances or relationships, no family members and both working in the workplace, things like that. I just think that's going to be hard for employers in today's world. And so I think you do want to be clear about your boundaries, whether it's a no PDA policy and what that is, and you have to enforce it as well. In addition to making sure that employees understand what can and can't be sent around the workplace, or, employees need to understand if two employees are in a relationship and they're in two totally different parts of a manufacturing plant, but they're still using the Wi-Fi or company devices to send each other sexy messages, we've got a problem. And I do think you've got to have rules for the electronic use. AIM is a huge one, or not AIM, Microsoft Teams. Sorry, gosh, I just aged myself with AIM.
You just did.
um, but Microsoft Teams, right? I mean, this is a way that employees can easily connect on a personal level while they're sitting there doing, work-related things, and they're there chatting about what they did for the weekend and connecting and whatnot. But had an interesting situation where an HR professional called me and said, I got one for you. And it's really, really pissing me off because these two employees, they don't realize that I have access to their AIM, but I know they're in a relationship. And this company had a policy that said employees could not work in the same department while being in a relationship. And this HR professional was pretty sure that these two employees were in a relationship. And in fact, another employee had reported to her. And this other employee, interestingly enough, because it's always like a fun soap opera, had dated the male employee. So it was a male and a female employee that were sort of dating or flirting, going out, seeing each other, whatever you want to call it. But he had actually dated another female in the department before that. And she was pissed off, of course, hurt. So she went and reported it to HR. So HR confronts both the male and female employee at issue separately, brings them in. Both of them denied it. She was like, I don't believe it. So she had IT pull their AIM, not AIM, Teams. Gosh, I keep saying AIM, their Microsoft Teams history. And in it, the two of them were communicating nonstop. It was very flirtatious, talking about, the intimate relationship they had or the dinners they were going to, the movies. Then also talking poorly about HR, laughing. Oh, yeah, she asked me this. Oh, no, I straight up denied it. Yeah, she has no idea. She's dumb as rocks. And basically talking crap about HR, that HR couldn't figure out that they were in a relationship. So she called them both back in, showed them the AIMs, and terminated them both. And so, I think employees, you've got to be clear to employees about what your policies are in terms of electronic use, how they're going to be communicating. At what point does a workplace relationship become distracting, and how you're going to train managers on addressing that. And then you also want to consider something like a disclaimer. So kind of your ducks in a row when you're dealing with these kinds of things.
And what we tend to forget is it has an impact on the rest of the team. It's not just those two individuals. It has an impact on the other employees who may be witnessing some fights or, distractions as well. and ultimately the turnover. I mean, if those employees are dismissed or fired, or that has an impact on the bottom line of the company. So it has so many facets. It's not
Absolutely.
just
Yeah, especially favoritism, right? Employees thinking,
oh, that
well,
too.
oh, they get, there's definitely favoritism there, especially if there's a subordinate involved, right? Or,
Yeah.
if two coworkers always get up in the middle of their daytime and go and hang out at each other's desks and flirt and talk about whatever it is because they're in a relationship. Whereas, if I were to sit at my desk and TikTok all day or something, right? Equally distracting, but I may face a consequence and they don't. It's because a manager may not see it that way. I think HR really has to come up with a way to convey these issues to those frontline managers that may be the ones kind of enforcing it, because it's really not going to be HR that's going to see this and deal with the workplace culture, the complaints, or the drama, right? If they get into a fight or whatnot. I had a case a few years ago that this kind of exemplifies how you want to make sure you're handling or managers are handling disciplining employees in workplace relationships. This was at a brewery. You had a waitress dating one of the cooks in the back of the brewery, and they had been on and off for years, and they got into a verbal altercation in the parking lot during working hours, and she pushed him, like physically pushed him. And so he shoved her back. Now, the manager came out and kind of saw this fight go on and kind of took this mindset that, like, oh, well, boys should never hit girls, right? Like, that was this mindset, disregarding the fact that she pushed him as well and ended
Mhm.
up terminating him. Well, he turned around and sued for sex discrimination, basically saying that the company held them to different standards. They disciplined them differently for engaging in the exact same conduct. And he had a
Mm.
pretty strong argument. And the EEOC looks at things like that, right? I mean, you can face discrimination isn't just about are you treated differently, but also comes down to are you terminated or held to a different standard? And is that because of your sex? And in this case, he had a good argument. So we had this sort of uphill battle. And so this really comes down to you got to have consistency on how you're going to address workplace romances when they start to get out of hand. You're going to have to hold them both accountable. You can't, I often get calls from clients that say, well, can we keep employee A but let employee B go because employee A is a really good employee, like a really great performer. Employee B is not so much, but I'm like, yeah, but they're engaging in the same conduct. They're both being a distraction or whatever it is, or you caught them making out in the hallway, whatever it may be. You've got to hold them to the same standard. So if you've got two employees in a workplace romance and one's really great and one's really poor, you've got to be prepared to let them both go.
I'd like to focus on professional breakups and conveying your reasons for separation effectively. We talked about romance. I guess a breakup is along the same vein of discussion. So, in most at will employment states, employees can quit their job anytime, and employers can let an employee go without giving a specific reason most of the time. But you say that it's very important to be very clear with an employee about the reason for termination. Why?
I will say it is one of the main responses that I during a deposition of a plaintiff or former employee who's suing, I always ask, "Why did you bring this lawsuit?" And the most common response I get is, "I was never told I did anything wrong. I have no idea why I'm being terminated." And there's confusing different, recollections of events in terms of what they're being terminated for. And I think that when people don't know what they're being terminated for, or it comes as a surprise, then it's going to lead them to wonder. They're going to go home and they're going to question and not have any ability to articulate what it is. And so they're going to think, well, maybe it is for an unlawful reason. Maybe it's because I'm a woman. Maybe it's because I reported harassment. Maybe it's because I complained that I was being forced to work off the clock. And so I think you can't rely on the fact that someone is at will. I mean, I think every state but one state in the United States is an at will employment state. I think Montana is the only one that's not. And so you can't rely on that to say as any sort of defense. You've got to be able to articulate what your reasons for terminating someone are. And you can't have differing reasons for terminating them. So, one of the things that a court will look at, an employee basically just has to go down to the courthouse and say, I think I was terminated in retaliation for reporting harassment. And then the burden shifts to the employer. And the employer has to say, no, 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 you weren't terminated for reporting harassment. You were terminated because you're a poor performer or you engaged in misconduct or whatever it may be. That's not the end of the story. The burden shifts back to the employee one more time. And the employee gets to try to call the employer out as a liar and basically has to try to prove that the employer's stated reason is bogus and is really just a false cover up for unlawful retaliation or discrimination or whatever it may be. And one of the ways that courts have identified as a strong way for an employee to do this is by pointing to the fact that there were differing reasons for their termination, or the reason for their termination was not clear. And so it may be that a supervisor says this, their termination paperwork says that, and then in response to their EEOC charge, a lawyer puts down something totally different as their reason for termination. So you've really got to have those clear reasons for termination.
So, what documentation process should HR professionals implement in their workplaces to avoid surprising employees about termination?
I mean, I'm a big fan of progressive discipline. Are you a fan of that?
Absolutely.
I think people hate when I say that because I think, or especially managers and maybe HR can relate to this, that managers sometimes get frustrated with this idea that their hands are tied because we're making them document 3 strikes before they're out, right?
Yeah.
But I think it's helpful because it forces a manager to, if you're ready to terminate someone to the point where they lose their income, they lose their health insurance, they've got to go home and tell their family that they no longer have a job and they potentially lose their identity, then you know what? You better have given them every opportunity to turn this thing around. Unless it's clear physical violence or misconduct, drug use in the workplace, something really egregious. I think it's important to have some sort of progressive discipline policy. We recently worked with a manufacturing plant where they had 3 or 4 lawsuits, one right after the other. And in every single lawsuit, we were dealing with a frontline supervisor who terminated an employee, like some sort of production coordinator or facilities supervisor who was terminating an operator, technician, some more lower level employee, just kind of off the cuff, right? Because the person either didn't show up on time or talked back to them or was just a poor performer. And none of these terminations went through HR. There were always differing recollections of why the person was terminated. They would just sort of say, oh, you're at will, you're terminated, or whatever it may be. And so we decided, look, let's get ahead of of the next type of lawsuit and prevent it. And so we put in place a really strong policy for this client that basically said before anyone could terminate an employee, they had to have HR involved in the conversation and signed off on it, and they had to have the plant manager involved in the conversation and signed off on it. So they took away that autonomy from the frontline supervisors. And that's helpful if you make a policy where you have to have more than one employee, more than one supervisor or administrator in terms of like HR or something involved in a termination decision. That gives a company sort of that backstop to say you have this third party like HR coming in and saying, okay, well, I know you want to terminate Leah for being late 3 times in 1 month, but our precedent is totally different. We've let Joe be late 20 times in 1 month. And, so we're going to have an issue here. And so I think you have to have more voices in the room for a decision as big as termination. And then you've got to have your paperwork in play, whether it's a first warning that's written up, a second warning, third warning, suspension, and then maybe termination, or a performance improvement plan, and then termination.
So, Leah, you are a principal at a law firm in Virginia called Woods Rogers. How can our listeners get a hold of you?
By email, Leah, Leah.Stiegler, Stiegler, at Woods Rogers, WOODSROGERS.com, or on LinkedIn, Leah Stiegler on LinkedIn, or follow our YouTube series, What's the T in L&E? And L&E stands for labor and employment, but also works for my name, Leah, and my co-host, Emily, for her name. And we do little 2 to 3 minute HR kind of legal updates every 2 weeks.
Listen, this was super helpful, and I'm very excited that we talked about romance in the workplace, this topic we've never covered before. So we're super thankful for your insights, Leah. Good having you on the show. Thank you.
Yeah, I enjoyed it.
Support for this show comes from Western Carolina University, a campus of the University of North Carolina system, with the technical assistance of Kelly Minnis.